The Constitutional Court has delivered a scathing judgment in the Public Protector Busisiwe Mkhwebane's bid to avoid paying a punishing cost order from the High Court.
In setting aside her report into the Reserve Bank and Absa Bankorp, the High Court in Pretoria held Mkhwebane personally liable for the costs, because this could see her forking out around 900,000 rand from her own pocket.
This court concludes that the Public Protector had a sufficient opportunity to deal with these facts. In addition, this court upholds the High Court's finding that the Public Protector acted in bad faith and agrees with the High Court that she exceeded the bounds of her potential indemnification under the Public Protector Act. This court holds that the Public Protector's entire model of investigation was flawed and that she was not honest about her engagements during the investigation. In addition, she failed to engage with the parties directly affected by her new remedial action before she published her final report. This court finds that the Public Protector's explanation for why she discussed the vulnerability of the Reserve Bank with the State Security Agency was unintelligible. Furthermore, this court holds that the Public Protector failed to explain why she did not disclose any of her meetings with the Presidency in the final report, or why, contrary to her general practice of producing transcripts of all meetings conducted during an investigation, she did not produce the transcription of her meetings with the Presidency or the State Security Agency. We also find that the Public Protector omitted pertinent documents from the record, some of which were only put up for the first time as annexes to her answering affidavit in the High Court, and others which were disclosed for the first time in this court. Furthermore, the Public Protector put forward a number of falsehoods in the course of litigation, including misrepresenting under oath before the High Court that the economic analysis that underpinned the final report was based on expert economic advice, whereas this was false, as the report was not based on expert economic advice. In this court, the Public Protector's various explanation of her conduct was contradictory. This court accordingly concludes that the punitive aspect of the court order against the Public Protector must stand in light of the standard of conduct expected from public officials and the number of falsehoods that have been put forward by the Public Protector in the course of the litigation. It is for these reasons that the Public Protector's appeal is dismissed.
Meanwhile, the Public Protector says she acted in good faith. Speaking to reporters shortly after the judgment, Mkhwebane asked for more time to study the judgment.
I've noted the judgment of the Constitutional Court, and I would want to say also the judiciary is a very important pillar of our democracy. And this judgment, especially the majority judgment, will then result in setting a precedent for the future public protectors. I must note that we are not government officials, which I've heard being mentioned, but we are a constitutional institution, an organ of state, and we have then a challenge that future public protectors, including myself, when I am doing my work, then there is that element of fear and prejudice on the incumbent. And I've noted the dissenting judgment, and which is giving hope, and especially those constitutional court judges who have also delivered their judgment, and it gives hope as well that they've taken note of the standpoint of the Public Protector. And thank you so much, and we will study the judgment and we will comment further on the elements of the judgment. Thank you.
Public Protector, they say you told falsehood under oath. Doesn't get more serious than that for an advocate?
I never told falsehood under oath. All the documents, we will study the judgment, and we will also study what is the reasoning behind that, because our papers were very clear what transpired during the process.
But if they say you can't appeal this.
I know quite well, and you should understand that there is a majority judgment, there's a dissenting judgment, and all of the elements will be taken into consideration. And I think, can you give me an opportunity to study the documentation so that we'll be able to respond comprehensively to this matter.
But when they say you acted in bad faith, and this is the Constitutional Court, the apex court, does it not mean that perhaps it justifies the calls by those who say you must actually step down?
I think I will study the judgment, and indeed, if this judgment is convincing or there are elements which then prove to them that I acted in bad faith, and I know I acted in good faith, and it's very clear from all my documentation that this investigation was conducted purely based on that. So I will study the judgment and I will respond comprehensively.
Let's get more on the story. I'm joined from our Cape Town studio by Lawson Naidoo for the Council of the Advancement of the South African Constitution, CASAC. And here in studio, I'm joined by Justin Ramages, who's an attorney at TGR Attorneys. Thanks both so much for your time. Justin, perhaps I'll start with you. In simple terms, what does this judgment say?
So a number of implications from the judgment. 15% of the costs that the bank had to bear, the public protector now has to bear in a personal capacity, which is quite a lot of money if you consider that last time I checked, she was under two leash, I think they were earning about 2.1 million rand. So if there's 900,000 rand to pay, that's half of your salary, you know, gone. So from a disposable income situation, that's bad for her. Secondly, it might freeze her. You know, ordinarily she's a gunslinger she's a head of a Chapter 9 institution going after state malfeasance and reporting on that. And now that might freeze her because now there's a adverse costs order against her. But those cost orders are very rare to be applied against her. And if you read the Public Protectors Act, I think it's section 5.3 specifically, she's indemnified against bearing a personal cost order. But in this case, the Constitutional Court found differently in this regard.
Okay, let's go to Cape Town. Lawson Naidoo, part of the judgment says personal cost order against public officials like the Public Protector whose bad faith conduct falls short of what's expected of them. That's quite a damning line in that judgment.
Indeed it is, and I think when we break it down, the judgment really finds that the Public Protector lied to the courts. She was not entirely honest with him. Her written testimony in terms of affidavits and so on, was filled with inconsistencies. She did not explain the secret meetings that she had with the presidency and the State Security Agency. And on all of those grounds, she failed to bring herself within the ambit of Section 5.3 of the Public Protector Act, which indemnifies her from a personal cost order. And it does so only when she acts in good faith. The court here clearly concurred with the decision of the High Court that she had misled the court, that she had not been honest with the court, and on that basis the court upheld the decision of the High Court and said that the personal cost order should stand. And I think given the scathing nature of the judgment, it's really untenable for Advocate Mkhwebane to now continue in office.
Justin, staying with what Lawson has raised about her continuing in office, Kampepe Jayantaron found that she put forward a number of falsehoods. For someone who's the head of a Chapter 9 institution, surely as soon as you read that judgment as she said she's going to do, you step down afterwards.
Sure. So it's interesting because the report is premised on economic expertise. And if you look at the date of her report and the date that Dr. Makoko signed his report, there are material differences. He obviously signed it afterwards. And obviously putting that forward, that her report is based on certain patterns and financial modeling, it's really inconsistent. And then if I can just tag on to what Lawson mentioned earlier on, there's a failure to clarify and a failure to submit in her report that she did have have secret meetings with the previous president, and in addition to that, the head of the state security agency. So if you throw that into the mix and you look at what your duty is as a head of a Chapter 9 institution and what standard you have to meet in terms of your investigation, the Concord came back and really echoed what the High Court has said. Listen, you fell far short of what was expected, and there's gross negligence, and that's why we need to award this, because what we expect and what you did, there's a stark difference between the two.
Mm-hmm. If the Constitutional Court had found, perhaps in the way it has against her, that judgment, Lawson, very scathing, as we've spoken about, but it didn't really pronounce on action besides costs, is that a way that also maybe she could be shielded from having to step down?
No, I think we've got to look at what the case was about. The Public Protector had appealed only against the cost order and against no other part of the High Court judgment. So the court really only had to look at the issue of the cost order. But in doing so, they have confirmed the findings that the High Court has made, which is the issues that we're discussing right now of untruthfulness to the court, the inconsistencies in her evidence, and the general way in which she went about conducting the investigation, which the Constitutional Court described as being flawed. And that really brings into question the competence of the Public Protector. And I don't think that Parliament can ignore this judgment any longer.
There's a sense that the Public Protector is under siege. There have been multiple and growing calls for her to step down. She has responded and said that she's just trying to do her job, and she wishes that she'd be afforded a certain amount of respect, because at the end of the day, all she's doing is investigating things that other people bring to her, and because there's big names involved, it seems like there's a contestation around not just the office but her as a person, and she feels she's being disrespected as the head of a Chapter 9 institution, as Advocate Mkhwebane, not as the head of that.
Sure, and she would take that view, obviously. But if we look at the old English proverb, what is it? The test is in the pudding, or whatever. We have to look at the facts and stack it up against her performance at the Estina judgment, this judgment. People taking her on review, and that becomes difficult when you say something, but when you put it to the test and people start looking at your work and start examining it, it falls far short of what is required of her performance. So while she may feel that she's under pressure, she's under pressure because of the poor performance, as the court said, in investigations.
Mm-hmm. Lawson, after that judgment was handed down, the Public Protector spoke and said that she's the head of a Chapter 9 institution. She's not a public official, referring to what was just said. Can you give us clarity on why she would perhaps want to make that distinction after that judgment?
I have no idea. Whether you're a public official or the head of a Chapter 9 institution, you're still subject to the law and to the Constitution and to the jurisdiction of the courts. So I'm not sure what straw Advocate Mkhwebane was trying to clutch onto at that point in time. But we have now a judgment of the Constitutional Court by 8 judges to 2 in a majority judgment that is very scathing of her. And I think any reasonable person on the basis of a judgment of that nature would immediately hand in their resignation.
Okay, you've just heard what Lawson has had to say, the Public Protector, after the judgment handed down, saying she wants to study the judgment very closely, and also bringing up that dissenting judgment. Perhaps, is there space for her to maneuver based on a minority judgment of the Constitutional Court?
Sure. Obviously, she would lean on that position. If you look at what her application brought forward, and her saying that, listen, what she'd like to do is she'd like to conduct investigations, and it's pro-democracy, and if the minority judgment feeds into that narrative, obviously she'd like to put that forward. But what Lawson is saying is correct. If you look at the majority judgment, if you look at the facts, if you look at how it's been structured, if you look at a performance, you cannot discount that. And so although you have a minority judgment which kind of maybe feeds into it and why she'd like to study it, you have to look at the facts. What did she do? How did it perform? And through a number of iterations of judicial hearings, she's been found to be grossly negligent and incompetent in certain respects.
Thanks both so much for your time. Justin Ramages joining us in our Johannesburg Auckland Park studio, and Lawson Naidoo in our Sea Point studio, discussing the judgment that's just been handed down a short while ago, the Constitutional Court. Nompumelelo, it's